A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
My bitch a choosing lover, never fuck without a rubber. Never in the sheets like it on top of the cover. Money on the dresser, drive a compressor. Top notch hoes get the most, not the lesser. Trash like the fuck for $40 in the club. Fucking up the game, bitch, it gets no love. She be cross country, giving all that she got. 1,000 a pop, I'm pulling business off the lot. I smashed up the gray one, bought me a red. Every time we hit the parking lot, we turn head. Some hoes wanna choose, but them bitches too scary. Your bitch chose me, you ain't a pimp, you a fairy.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
Baby, you been rolling solo, time to get down with the team. The grass is greener on that other side, if you know what I mean. I show you shit you never seen, the 7 wonders of the world. And I can make you the 8 if you wanna be my girl. I say my girl, I don't mean my woman, that ain't my style. Need a real street stalker, walk a green mile. You piling up the paper on the dining room table, cause you able to realize I'm the truth and not a fable. Baby, rockin' Russian sable, keep that chiller on the rack. What I look like with some $1,000 shit up on my back. I'm $1 million man, they need $1 billion bitch. Put my pimpin' in your life, watch your daddy get rich. Easy as ABC, simple as 1, 2, 3. Get down with UGK, Pimp CBU with B. Cause what's a hoe with no pimp, and what's a pimp with no hoe? Don't be a lame, you know the game and how it goes. We try to get toes.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
Hey, what's going on, everybody? It is Artie of Artie's Corporate Fiction. How you guys doing this evening? Happy Wednesday to all of you. A pretty packed evening tonight with a lot of us creators putting stuff out there. But today, as promised, I'm going to take a look at the Earl David Warden, Mr. News Now Houston, now convicted offender. News Now Houston. He has filed a motion for new trial. We're going to take a look at that. It's about 30 pages. We're not going to go too deep into it. And then we're going to listen to the pretrial hearing that I alluded to on Monday involving a traffic case in Georgia. And you're going to hear a lot of the same arguments put forth as we heard from the Texas traffic case that we listened in on last week or the week before. We're going to take a look at, and since that one's also audio only, I'm probably going to boot up something to play, something for you guys to watch while we listen in. Still don't know yet. Debating between Skyrim, Witcher, or Dead Space, but we'll figure that out when we get there. So we're going to take a look at that, and then let us put it here. Right here we got State of Texas versus Earl David Warden. Hollow Knight. Nah, not Hollow Knight. Avalon, thank you for the 4 months and 3 months. Randy, thank you for the 21 months. Appreciate it, both of you guys. Before I start, how's Danny? She's fine, actually. We've already made plans to see each other again soon. So, always good. Sounds like 8 coming in. Hopefully that's not happening right now, but we'll see what happens there. Thank you, Matt Hatter, for 7 months. And thank you, David, for the membership. Welcome, man. All right, we're gonna hold on. Motion for new trial. Earl David Warden. Through his attorney, files his motion for new trial. 1. He has a artifact there. In the and pursuant to the Rule 21, based on the state's flagrant injection of racial and religious animus and stereotyping into the trial in violation of the First and 14th Amendments to the U.S. Constitution, Rule 404, the Texas Rules of Evidence, and Article 38.37 of the Texas Code of Criminal Procedure. Repeated outside influences on the jury and jury misconduct, including an attendee perceived to be an associate of Mr. Warden, following jurors through their cars, communications and attempts to communicate to jurors, including individuals against Mr. Warden, shouting that other attendees were supporting a rapist and sex offender within earshot of the jury, and the court impermissibly commenting on the weight of the evidence, and that the jury heard about, quote, 25 years of this dysfunctional family in 2 days, end quote, and it repeatedly emphasizing to the jury that there was a lot of crazy stuff on the internet about Mr. Warden. If they were to Google him, these outside influences violated Mr. Warden's right to a jury trial and his right to the process of the 6th and 14th Amendment. And number 3, the state's presentation of false and misleading evidence before the jury that Mr. Warden was a racist and a Mormon. And number 4, ineffective assistance of counsel in failing to object to the prosecutor's injections of racial animus into the trial, and failure to object to the prosecutor's closing arguments that Mr. Warden was racist and Mormon. Mr. Warden is charged, by indictment with the offense of sexual assault of a child under 17 years of age, turned July 2nd, 2019. After litigating numerous pretrial issues, he entered a plea not guilty and proceeded to trial in December 2022. Sorry, hold on. I'm sorry. Wanted to fix something right quick. There we go. All right. Trial was held before emergency relief docket. Presided over Jim Anderson. Mr. Warden is a well-known police accountability activist and publisher. I mean, I by publish, if by publish you mean upload videos to YouTube, I guess.
And there was much rejoicing.
Hey, thank you, Akira808 State, for the $4.99 super chat. Thanks for the information, Artie. Thank you very much, man. With a large fan base, it includes a large number of internet followers. Mr. Warden's activism made him a target of a large anti-fan base that includes individuals Teresa Richard and Douglas Ripley, both whom attended the trial. Mr. Warden's celebrity within that activism community made the trial of particular interest to his fans, his anti-fans, and those generally interested in police accountability issues. Well, it could also involve people who are interested in sexual assault stuff. Mr. Warden's activism has also led to the instant charges being filed. Oh, is that right? Mr. Warden had been publishing about a security head at the Shell refinery in Deer Park. Again, publishing. You mean recording stuff. Recording, you know, a Shell refinery in Deer Park, as I recall from this whole incident. Which led directly to the Deer Park Police Department beginning an investigation into Mr. Warden. The Deer Park Police Department initially tried to have Mr. Warden charged with sexual assault against another person, not the complainant in this case, but was unsuccessful, as they refused to accept charges. The investigation then moved to the complainant in this case, who had not made any contemporaneous outcries of sexual assault. As discussed in defense counsel's affidavit, the evidence of sexual assault was scant. There was no contemporaneous outcries, no physical evidence. The allegation that Mr. Warden snuck into the complainant's room each night for 2 years at a trailer house with 7 other people without anyone ever noticing anything seemed impossible. Additionally, defense heavily relied on the contention that the complainant's story lacked credibility, as the complainant's story changed not only prior to trial, but also during her testimony before the jury. The complainant's claims were also contradicted by other state and defense witnesses, including her sister. These direct contradictions were made subject of several juror notes during deliberations. I mean, okay. So it's, I'm sure the jurors will take notes on that. And the issue will, the contradictory statements by the complaint is also going to be noted, as well as the objecting testimony of the defense witnesses. The state's injection of race and religion into the trial. During the complainant's testimony, the state presented highly prejudicial, inflammatory, and unnoticed bad act evidence against that Mr. Warden refused to allow his wife to live in their trailer home because she became impregnated with a black child. The state's emphasis was not on any fact that she was impregnated with another man's child, but specifically that the child was excluded because he was a black man's child, that the child was black. Well, if I'm being real here, I don't know if any of this is necessarily relevant. Then again, well, I guess they might have testified as to where was the mom and where was the mother during this incident, I guess. Thank you, Joan, for the 6 months. State emphasizes this point with defense counsel recognized as zero to do with any elements or issues involved with Mr. Warden's trial during his closing arguments. But then why didn't you object to it at the time? The prosecutor, herself a black woman, emphatically raised her voice and pointed at Mr. Warden during these remarks of her closing argument, asserting to the jury, which was comprised of at least 4 black members, that Mr. Warden was racist because he would not raise a black child, nor allow his wife to live with him while she was pregnant with a black child. The Hart Affidavit. Defense counsel recognizes that this claim against Mr. Warden had never been made prior to trial, caught him off guard, and that he failed to object to this testimony, which would have been inadmissible. Well, the problem is that if you don't raise the objection, you may forfeit it on appeal. That's going to be a problem for him. The fact that he failed to raise the objection is going to be the issue here. Because if you don't raise it, you waive it. In the vast majority of instances. Defense counsel Landers recognizes that the damage was done by the state's presentation and emphasis on their claim that Mr. Warden is racist, and that this unnoticed bad act evidence was very harmful and cast Mr. Warden in a troubling light. The state went even further, claiming that Mr. Warden was a Mormon. Oh my God. And he tried to make the complainant convert to Mormonism so that he could marry her. The suggestion was made to the jury that it is acceptable in the Mormon church to marry one. The suggestion was made to the jury that it is acceptable in the Mormon church to marry one's own children. I mean, in the fundamentalists, maybe. I don't know if that's the case in the mainstream Mormon church, but I couldn't tell you. During closing arguments, the state was again pointing and yelling at Mr. Warden and claiming before the jury that he used Mormonism to try and marry his daughter. That's a pretty wild statement to make in closing arguments, in fairness. Defense counsel Landers objected to the state to ask questions about Mr. Warden being a Mormon during the trial. Okay, so he at least objected to those questions. The court sustained the first objection, but overruled the second objection. Trial counsel failed to object when the state argued the improperly admitted evidence during closing arguments. The state's presented attacks on race and religion were not only inflammatory, they were false and misleading. Mr. Warden is not a racist, nor has he ever been Mormon or a member of the Mormon church. Warden's a longtime Baptist and even attended Baptist schools growing up. I'm sorry. Teresa, Richard, Douglas, Ripley. I don't know who these guys are. They may just be, anti-fans. And But who knows? We'll see. Other attendees, including John Gray and Justin Pulliam, I think we all know. I think we definitely do know who Pulliam is. Sat on the side of the courtroom associated with being for Mr. Warden. Well, this is an attorney's brief. Just to give you guys this is a motion for a new trial, and this is this brief in favor of the motion for a new trial. These are the claims and allegations, but you see in the exhibits, these are all affidavits. The affidavits are the evidence, as it were. There, it's going to have the prior counsel, the previous counsel, as well as other affidavits. So that's the evidence, as it were. But I think it said in the footnote that they still haven't yet to provide a copy of the transcript, which I assume they're going to have to get. Because, of course, the court is going to cross-reference what's being claimed here in the affidavits and the motion with what's in the transcript. The court bailiffs, the prosecutor, and defense counsel were actively concerned that attendees might try to influence the jury. The defense brought up these concerns with the court on numerous occasions, including with prior judges who presided over the pretrial settings. Compounding these concerns during the trial, the jury was walked in and out of the courtroom during the same doors that was used by the general public to enter and exit. And the jury used the same elevators used by the public. He included his supporters submitted affidavits, because of course they did. Pulliam submitted an affidavit and Gray submitted an affidavit. I should have known. Those concerns came to fruition during voir dire. Defense counsel observed Mr. Ripley speaking to a veneered member. This was brought to the attention of Judge Yates, who ejected Ripley from the courtroom. Okay, so that's appropriate. If one of Warden's anti-fans were talking to a member of the jury pool, yeah, they needed to get the hell out of there. Mr. Ripley was allowed back into the courtroom during the subsequent trial days. Attorney observed Mr. Ripley would loiter in the hallways and near the elevators, which were within earshot of the jury room, and that he would frequently observe Mr. Ripley near jurors who were both coming and leaving during the breaks and after the trial days. Okay, being near them is different from talking to them. But assuming this guy is an anti-fan and not a secret troll, you never know. He's an idiot. He's being an idiot, and he's sabotaging the prosecutor's case against Warden. More troubling issues were observed. Gray observed Ripley and Richard were observed in the hallway by the elevator banks. They were in heated discussion in an argument with Jack Miller, another attendee, and Miss Richard told Mr. Gray and Miller that they were supporting a rapist and sex offender. This was within earshot of the jury and was loud enough to get the bailiff's attention, who came around the corner to the elevator area. Tara Saber, the significant other of Mr. Warden's son, also attended the trial. She was outside the courthouse smoking a cigarette as jury deliberations ended on the first day, and jurors exited the courthouse. According to her, she observed that she saw Miss Richard was outside initially on the sidewalk nearest the courthouse, standing with an older gentleman. Miss looked away and saw that the two female jurors were across the perpendicular stanges in a street. She states that as she looked back to her left, she observed that Mr. Richard had crossed Franklin Street. He was talking to two men she identified and believed were. Okay, really? So this lady is submitting an affidavit that she thinks that she saw these two anti-fans talking to what she believed who she believed to be were jurors. Because, well, wait, in the previous sentence, she said she saw two female jurors that were across a perpendicular street, but then she said that she claimed that she was that Miss Richard, an anti-fan, was talking to two men she identified and believed were jurors. Miss Richard spoke to the two men, an older white gentleman, beard, and the younger skinnier male with a male for about a minute. She does not know what Miss Richard said to the jurors, but observed her speaking to them from across the street. Jurors also reported that following the first stage of the deliberations, they were followed to their cars by Mr. Gray. Wait. Bear in mind, Mr. Gray is okay. Bear in mind, you guys, Gray is one of Warden's supporters. So Gray, based on the affidavits of the defense counsel, was the one who was approaching jurors with a camera and recording equipment. And so what? He's going to try and use his auditor buddy's antics to try and get himself out of get himself a new trial. That's BS. Mr. Gray confirms that outside he encountered a group of individuals he knew were jurors and saw the jurors looking at him and walked a couple feet behind the group. Mr. Gray confirms he was carrying his camera equipment. He states that he walked to those jurors and even walked within their group until he realized he was walking in the wrong direction. States that he began to walk back to the courthouse where he encountered a second group of jurors that he recognized. He made eye contact with those jurors, walked through the second group, stated he proceeded to go into his car. So what? So he's trying to use that? The jurors reported they were being followed by Mr. Gray to the court. When Mr. Gray came into the courtroom the following day, again carrying his camera equipment, he was confronted by Judge Anderson, who asked the bailiff, "Is this guy messing with my jury?" Bailiff said the two jurors confirmed that Mr. Gray was the person who had followed them, and he ordered Mr. Gray out of the courtroom. Following the guilty verdict, Judge Anderson recognized the impact that Mr. Gray, who the court and presumably others associated with being in support of Mr. Warden, had on the jury. It is recalled that Judge Anderson stated, Mr. Warden's friends didn't help him out too much, and or your friends haven't done you any favors with the jury. He's probably right. And or his friends had done him no favors to the jury, and the jurors were scared. Anderson indicated that Mr. Warden should think about dismissing his friends from the courtroom because having them in the court could harm him if the jury decided punishment. The jury itself seemed to be greatly troubled by these issues, even going so far as to write a note to the court asking the court refrain from using names to refer to die jurors. Juror note number 11 read, "Please refer to me as foreman and not last name due to not wanting the audience to know last name." The trial court itself also served to be a source of outside influence during jury deliberations. At the end of the first day, jury indicated that they were gridlocked in the 6-6 vote. The jury was brought into the courtroom, and the court inquired as to whether the jurors felt that additional deliberations would be beneficial. Defense counsel recalls that 6 jurors explained that they would not be changing their vote. Just before the jury was released for the day, the court told the jury that they had sat through 25 years of dysfunction of the Warden family, which had been distilled into 2 days of testimony for them, that they should evaluate their conscience. Well, if the court, I'm presuming here that the jurors of those jurors that explained that why they would not be changing their vote, that you don't know on what side they were on in that. They could have been, all 6 of them could have all been the ones who already labeled them as guilty, but they could not be. You don't know that. The trial court also reminded the jury, as it had throughout the trial, that if they Googled about the case, there would be crazy stuff out there. The repeated emphasis was not merely that the jury should not consult or read any outside sources, but rather focus the jurors on the information they would find if they were to do so in a way that seemed to create interest. How come the trial wasn't on video? I don't know. Your guess is as good as mine. All right. here we go. Into the arguments here. Mr. Warden's conviction was a result of state's injection of racial and religious animus and stereotyping trial, outside influences, state use of false and misleading evidence, and the ineffective assistance of trial counsel. He's not. Marry her. 3, violated his rights. Yada yada yada. 404 evidence was entered in as they were unnoticed extraneous bad acts. Okay, the problem is that for a good chunk of them, defense counsel didn't raise the objection, so it's going to be very questionable whether they're available to be made under appeal. I'm very curious about that. In Dawson versus Delaware, Supreme Court recognized that the First and 14th Amendments of the Constitution generally precludes the use of an individual's associations and beliefs, where those associations and beliefs are not relevant to the issues involved in the case. I mean, I agree. I agree with him in the sense, like, you know, bringing up that he wouldn't let his wife into the house or the trailer because she was pregnant with a black child is not really relevant as to whether or not he assaulted his daughter. The same as raising whether or not he was a Mormon. Although, if they're going to, I don't know. I don't. Well, the Mormonism thing, the state tried to make the argument that, allegedly tried to make the argument that he was Mormon and wanted to marry his daughter as part of his Mormon religion. But I mean, that still doesn't really raise. That's still not necessarily relevant as to the evidence as to whether or not he assaulted her. So his motivations for assaulting her, I mean, they might be relevant, but I don't think that they, I mean, I guess they could be relevant in that sense, the motivations behind it, but I don't know. The premise underlying Dawson's holding is first and fourth protects their neutral by growing groups, not associated with others, and only moreover, the state's use of harmful and divisive stereotypes, whether they're racial or religious, without any compelling justification, violates both due process and protection. Finally, Texas Rule of Evidence 404 prohibit the use of unnoticed, extraneous bad act evidence, and the state's offered evidence was unnoticed. The state sought to inject these proceedings with allegations that he harbored animus towards individuals on the account of race.
And there was much rejoicing.
Thank you, Poetic Justice, for the 6th month. If anyone can screw up a good conviction, it's the Harris County DA's office. State introduced this evidence for the purpose of attacking and penalizing Warden based on their false idea that Warden had a belief that involved him not associating with black individuals. Damaging, inflammatory. I mean, I would say, making allegations that he's a racist in a case where race really isn't relevant. It would be relevant if this was categorized as a hate crime, right? But not here. It's about assaulting his own daughter. The state's case against Mr. Warden was weak, unsupported by any contemporaneous outcry or by any physical evidence. The allegation pitted the credibility of the complainant. The story changed not only prior to trial, but also during a testimony before the jury. Versus the perceived credibility of Mr. Warden, the state maneuvered through this weakness by presenting Mr. Warden was a racist. So he's trying to argue that because the state's only major source of evidence is the victim's testimony, they tried to shore up their case by accusing Warden of being a racist and as a fundamentalist Mormon. Compounding this error, they also presented that Mr. Warden was a Mormon, that he attempted to get the complaint to convert to Mormonism, and did so because it is acceptable to the Mormon Church. Again, and Danny kind of confirmed what I thought too, is that I think that's a fundamentalist belief, not the mainstream church. But I digress. An individual has a First Amendment right to express free exercise of his religion, presenting of evidence that he's a member of the Mormon Church and that the church permits marrying of one's own children, runs directly afoul of Dawson and his progeny. The state's assertion was, again, nothing more than an attempt to use the stereotypes of Mormon Church to penalize Mr. Warden for his alleged abstract belief, and was employed simply so the jury would find these beliefs morally reprehensible. Mr. Warden requested this court find that the state's presented claims of animus, racial animus, and religious stereotyping violated his First Amendment rights to freedom of association and free exercise of religion, and violated his 14th Amendment rights to process and protection. And they violated Rule 404 of the Rules of Evidence and 38.37 of the Code of Criminal. Mr. Warden moves his court pursuant to Rule 21 to hold a hearing for a motion of new trial, allow the presentation of both affidavits and live testimony to support the presented claim, and find that Mr. Warden has established error raised herein, make oral or written findings of fact, and enter a written order commanding that a new trial should and must be granted. Now, okay, now we're going to the outside influences. I want to hear what he's going to try and say here. Impartial jury, get it, of course. Properly brought to the jurors. An outside influence is something originating from a source outside of the jury room and other than from the jurors themselves. Then, without delving into the jurors' deliberations, the trial court must on objective analysis, I guess must employ an objective analysis to determine whether there is a reasonable probability that the outside influence had a prejudicial effect on the hypothetical average juror. Mr. Warden meets the standard. Numerous outside influences plagued Mr. Warden's trial were brought to the bear on the jury, including an attendee perceived to be associated with Mr. Warden, following jurors through the cars, communications. So, Guy, I think Sky, you guys in the chat mentioned it. Gray is extra good citizen. Is that right? I know who Justin Pulliam is, but Mr. Gray is extra good citizen. Anyway. Trials mid-deliberation comments that they had heard about 25 years of this dysfunctional family. Okay. Family in 2 days. The trial court's repeated emphasis that there was a lot of crazy stuff on the internet on Mr. Warden. If the jurors would Google him. Outside influences are impermissible and originating from outside the jury room and not a result of the actions of the jurors themselves. An objective analysis of the events establishes a reasonable probability that these outside influences would have a prejudicial effect on the hypothetical average juror. Such concerns inevitably became aimed Mr. Warden's way, as the trial court itself made clear when it told Mr. Warden that his friends had not done him any favors. Mr. Warden ultimately became seen as being accountable for Mr. Gray's individual unacceptable conduct. Possibly. Maybe. Yeah. Attendees actively against Mr. Warden, speaking to the jurors outside the courthouse in a minute-long conversation with Warden just again. We're assuming that what his affidavits. We're assuming that all the affidavits that he's supporting all contain factual information, that they're all true. These attendees were not there to help Mr. Warden receive a fair trial when it was ordered at the courtroom after speaking to veneer panels during voir dire, and the attendee speaking to jurors was also in the hallway outside the courtroom, shouting that Mr. Warden was a rapist and sex offender within earshot of the jury. The court's commentary that this is 25 years have a prejudicial effect on the average hypothetical jury. A court's mid-deliberation commentary, the jury saw 25 years of this dysfunctional family, particularly right before the jury went home for the day. It makes any rational person wonder what caused all this dysfunction the court mentioned. Sexual abuse. This commentary prejudicing Mr. Warden came from the most authoritative source of the entire process, the court. I mean, if he said that, I think I could see that if he said that, I could see where the prejudice could happen. But I mean, and let me put this way. I'm trying my best to be as objective as I can, because I despise News Now Houston. Don't get me wrong. I'm trying to be as objective as I can. If all the if all the state's evidence
much
is the testimony of the victim, I mean, I could see where some of these actions could lay enough to influence the jury to its verdict. I don't know if that's the case. I wasn't there to trial, and I'd have to go and find the people who were commenting on the trial. But most of the people who are commenting on the trial are either anti-Warden or pro-Warden, so it's hard to find an objective situation without you and I taking a look at the transcript and seeing what was said during the trial. The court's repeated emphasis I believe he got 20 years. Emphasis there were crazy stuff on the internet about him, served as an outside influence to affect the average juror. Moreover, the follow-up events make clear the jurors were impacted by these issues as an initial matter. Okay, they were evenly split 6-6, and about half the jurors indicated additional deliberation would do no good. Again, we don't know on what side of the fence they were on of those jurors who said that. The jurors then adjourned for the day and then returned to their car, and then returned jurors reported to the court that they had been followed by to their cars by Mr. Gray. Additionally, the jurors' final note raising concerns about audience members and jurors' privacy concerns in light of the ombudsman. The jurors were actually impacted by these outside influences, same as any hypothetical average juror would be. Okay, so I don't know if I agree with this. What this attorney's trying, raising the implications here. That, I mean, and it's very possible, and it could be, and I don't think that it's something that we should ignore. But the way he's acting is that anybody could, if anybody wants to sabotage a trial, they just need to, harass the jurors enough. And then resulting in what? Every single juror in a criminal case has to be sequestered? I don't know. There's a lot of issues raised here. I understand that outside influence affecting the jury can be a thing, and can be a thing that's significant enough to warrant a new trial. But I mean, it's kind of almost establishing a golden playbook as to how to get your buddy a new trial if you don't think it's going your way. Motion for new trial. Mr. Warden moves his court pursuant to Rule 21 for a new trial. Present evidence and the false and misleading evidence. They racist and a Mormon. Perjured testimony. Okay, so now they're raising the argument that the state violated one of the court rules. Okay, here we go. Due process prohibits the state from securing a conviction through the use of false or highly misleading evidence. Conviction through the use of false evidence under federal precedent is not necessary. The prosecution actually knew the testimony was false. It is enough that the prosecution should have known as much. Although the case law in this area frequently refers to perjured testimony, there is no requirement that the offending testimony be criminal perjurious. Rather, it is sufficient. My bad. It is sufficient if the witness's testimony gives the trial of fact a false impression. These rules are not aimed at preventing the crime of perjury, which is punishable by its own right, but is designed to ensure the defendant is convicted in the sentence on truth testimony. Under the federal precedent to constitute violation, He must use knowingly false testimony. However, the Court of Criminal Appeals allows the applicants to prevail on due process claims when the state has unknowingly used false testimony. Unknowingly used false testimony. Convictions based on false evidence may be reversed. If the false evidence may have had an effect on the outcome of the trial, this is known as the materiality prong. Warden must show that the false evidence was presented at trial. The prosecution team knew or should have known that the evidence was false, and the false evidence may have had an effect on the outcome of the trial. Mr. Warden is not racist. Okay. Mr. Warden is not a Mormon. Okay. And the state's presentation of this evidence was both patently false and misleading. And he was reincorporating what he previously said, that these statements were materially prejudicial against him. Mr. Warden moves this court pursuant to Rule 21 of the appellate to hold a hearing. Oh wait, we already read this. And now, okay, deprivation of his right to effective assistance of counsel. Okay. Here. Mr. Warden should be granted a new trial because he was deprived of counsel, where the counsel failed to object to the state's injection of unnoticed and false allegations that Mr. Warden was racist to his wife's in her home. So basically, that's where he's saying that he had ineffective assistance of counsel because he failed to raise an objection that was highly irrelevant and prejudicial against him. That's their out. Basically, that their out is that the that they didn't raise it and therefore couldn't they waive the objection at trial, is that he had ineffective assistance of counsel because he's going to argue that any lawyer of effective competency, of measured competency, knew or should have known to have objected to those to that testimony at the time, but he didn't. The claim on ineffective assistance of counsel. Applicant must establish by providence of evidence that trial counsel's performance was deficient and that this deficient performance deprived applicant of a fair trial. Objective standard of reasonableness. There it is. Stated differently, the applicant must show by preponderance of evidence that trial counsel's actions did not meet the objective norms for professional conduct. Restated, the second prong. Restated, this requires establishing that there is a reasonable probability that, but for the trial counsel's deficient performance, the outcome of the proceeding would have been different. All right. Incorporated. A trial counsel had a duty to keep the evidence out under the First and 14th Amendments and under Rule 404. Trial counsel recognizes that he failed to. So the trial counsel in his affidavit is likely saying that I messed up. Trial counsel recognizes that he failed to lodge any objection to the relevant testimony portions of the racial animus, and trial counsel failed again to object when the state offered this testimony during closing arguments. Had counsel objected, the court would have been legally required to keep this evidence of racial animus out. The failure to object constituted deficient performance under the first prong. Additionally, there could be no reasonable or constitutionally acceptable trial strategy for allowing such an inadmissible evidence into a trial. In addition, though trial counsel properly objected to the religion evidence that Warden was a Mormon seeking to marry his own daughter, trial counsel failed to object when the state emphatically argued this testimony during closing statements. So he's saying that as a result of this, Warden was significantly prejudiced by trial counsel's failure to object. Not only did the state present this allegation against Mr. Warden during testimony, they emphasized it in closing statements, including by shouting and pointing at Mr. Warden during the relevant portions of argument. state used this evidence to merely show that Mr. Warden was a morally reprehensible person so that they would find a way to believe the contradicted testimony of the complainant. This evidence was offered only to attack his character, make him seem repugnant, and offered no value to the issues at trial. So again, they want the court to hold a hearing on the motion for new trial, grant it, and all other relief as can be provided. So if you guys want my honest opinion, I can't give you my opinion with confidence because again, I'm not an appellate attorney and I'm not a trial attorney. But I will say if we're going to only look, if we have the blinders on and only look at what is being presented here, and we're going to assuming everything in the affidavits are true and accurate, there could be grounds here for a new trial, as evidence of juror influence, allowing damaging and irrelevant testimony into the trial without objection, and potentially the court statements. I'm not sure if I'm buying that one as much, but really the influencing of the jurors and the allowing some pretty damning testimony that's not relevant to the case could lead to a new trial. However, again, I'm only looking at what's being presented in terms of this brief and this motion. We haven't seen what the state has said yet. The state is obviously going to file their objections to a motion for new trial, and it's likely that we're going to have some arguments and facts or alleged facts that contradict what's being stated here by the state. So that's where we're at right now. Again, that I'm making the grand leap and assuming everything said in the affidavits are true and accurate, which no, I don't buy that for a millisecond, especially anything coming from his sycophantic followers, making claims that that his anti-fans were prejudicing the jury, especially when they admit that they were unduly influencing the jury themselves. So that's gonna be that one, but I want to appreciate it, guys. But that's gonna be my take. Again, assuming everything in there is true and accurate, there can be a case here for a new trial, but we'll see. I will be anticipating heavily for the the state's objection to the motion. So if and when that happens, I'll obviously be going over it with you guys. So all right, this is the New Yorker. I've been catching up on. Apparently you're supposed to pronounce the last name as Murdoch with a K instead of Murdaugh. Whatever. All right. Next, we're going to go to this audio again. I affected the audio that it hopefully will allow you guys to hear the court better. I ran it through a filter to help it out. But we're going to do that while I go ahead and boot up something to play. I don't know. What do you guys think? Witcher? We're good? Witcher. Or we could do Modern Warfare. I don't know. No, not Modern. Dead Space is a bit. Let's go.
Okay, thank you for that. So I'm just going to, unless you have any objections, I'm just going to start from the top and read through the motion, given this is the first time everybody's seen this. Is that okay?
I've read it. You don't have to read it verbatim.
Okay.
If you want to further expand on any particular point, this is your opportunity to do that. You don't have to just read it because I've already read it.
Yeah, I mean, and I'm not sure if I really need to expand. If there's an objection on something, I certainly would expand on something like that. But, you know, without reading it verbatim and you guys just seeing it today, I'm not sure what the objections would be. So, I mean, again, I can read this out loud if it pleases the
It's
court.
not necessary to read it out loud. Like I said, you can argue, you can...
Okay, well, high level...
offer any additional arguments.
Okay. Well, just to kind of sum things up, as I mentioned, Georgia Constitution Article 1, Section 1, Paragraph 1 states, no person shall be deprived of life, liberty, and property except by due process of law. The municipal court in the city of Ball Ground is an improper venue because it's not a court of record. And we see this in DeKalb County versus Deason. That's 221 Georgia, 237, 238, 1965. And it says the presence of the following characteristics have been considered as an indicative that a particular court is a court of record. Whether or not such a deal is not crucial. United States versus Mayor. The court has what counts is whether the witness may have power to fine and imprison the court to please the prosecution.
Wait, what the hell is being played here?
Desire to cooperate may be formed beneath the conscience level in a manner not apparent even to the witness, but such a subtle desire to assist the state.
What the hell is being played right now?
And makes his testimony void. So basically what we have is a UTC which is not allowed to be used as evidence, but it is allowed to summon me to the court today.
Oh, that's why. My bad. All right, we're good.
The municipal court is not authorized, therefore.
Oh, yeah. The other thing I wanted to mention to you guys is that I am now going, now that I got my replacement 4090 and it's working beautifully so far, I'm going to be streaming simultaneously on Twitch from here on out. So if you guys go on Twitch at all, you know, you could follow me there. You can also send me your Prime sub if you're a member of Amazon Prime, etc. But I now have a way of being able to see both chats at the same time, and chat will also be in the video as well. So you'll see both Twitch and YouTube. What? What do you mean by what happened to the first one? I don't know what you mean by that here. But I'm actually streaming on Twitch right now, as a matter of fact. So nobody's watching, or at least I haven't noticed, but it is. All right.
A motion for a new trial will not.
Thank you, Chaos Warden, for the $100 super chat. Yes, my Twitch is Artie's corporate gaming. You can find me on Twitch there. I need to update the links, but my Twitch name is Artie's corporate gaming, since I'll be doing both gaming and non-gaming content on there. Thank you, Chaos.
Must be filed. So this court also lacks subject matter jurisdiction. Subject matter jurisdiction has failed because it has not provided this court with a valid indictment. So pursuant to Georgia Constitution, Article 1, Section 1, Paragraph 4.
As you guys can already hear, he's using the exact same argument as the Texas guy, that the citation he received does not count as an indictment or anything of the sort. So. Hello, Kimber, Jassa, Blue Max, Richard. I see you guys. I actually see you guys. Finally.
Every person charged with an offense against the laws of the state shall have the privilege and benefit of counsel, shall be furnished with a copy of the accusation or indictment. So that has not been done today. The indictment is legally sufficient when it contains essential elements of the charged offense. It notifies the defendants of the charges to be defended against and protects the defendant from double jeopardy. That's United States versus Leonard. That's 4F.
I hadn't seen it yet, Justice. Sorry.
2021. Also in King versus State, 335. SC 2D 439, Georgia Court of Appeals in 1985. So the Ball Ground Police Department has failed to allege essential elements on their charging instrument. This is resulting in a void indictment, or UTC as it's being called. So a motion and arrest of judgment will lie where there is a defect appearing on the face of the indictment affecting the substance and real merits of the offense charged, such as the omission of an essential element of the crime, so it renders the indictment void. That's Ponder versus State, 175 SC 2D 55, Georgia Court of Appeals, 1970, citing Rambo versus State, 25G Appeals Court, 390, 103 SC 494.
Hype train started.
Again, if you would like any of these cases, please let me know. I have them printed out. So Jackson versus State, 800 SE 2D 356. That's the Georgia Supreme Court in 2017. States due process of law requires that an indictment which a defendant is convicted contain all the essential elements of a crime, which again this UTC does not. Due process requires that an indictment put the defendant on notice of the crimes which he is charged and against which he must defend, which I have no way of defending the UTC because it does not allege essential elements of the crime. In Georgia, a defendant has a right to be tried on a perfect indictment, which is perfect in forms and substance. That's State versus Black, 149 Georgia Court of Appeals, 389, 391, 4, 254, SC 2D 506 in 1979. There has not been proper service applied to my person in pursuant to OCGA 17-1-1. Again, another reason why this court lacks matter jurisdiction. As it relates to personal jurisdiction, this court lacks personal jurisdiction for the various reasons that I've already stated. Also, if we look to OCGA 40-13-21A, it states that the probate courts and municipal courts of incorporated towns and cities of the state, acting by and through judges or presiding officers thereof, shall have the right and power to conduct trials, receive pleas of guilty, and impose sentences in the manner required by law upon defendants violating any and all criminal laws of the state related to traffic upon the public roads, streets, and highways, which again, that has not been alleged here today via the UTC. So personal jurisdiction is obtained by appearance, which today I'm appearing under special appearance to you today just to challenge the jurisdiction of this court by serving the process in a manner required by law on persons or parties subject to it. So lastly...
He kind of goes... does kind of go pretty long-winded, but don't worry, this pre-trial is like only 40 minutes long. It's not like the Texas thing, where it's like multiple days. This court lacks jurisdiction because it has failed to state a cause of action. So again, for the reasons that I've stated already, also Georgia Constitution, Article 9, Section 2, Paragraph 1, the General Assembly has created the City of Ball Ground, which has been delegated authority to self-govern itself, not repugnant to the Constitution of this state. So again, if we don't have a perfect indictment to move forward with the prosecution, then this court lacks jurisdiction to see these matters. And I have a couple of other citations if you've read the motion that I've submitted to you to try to help speed things up. As it relates to my interaction with Officer E.J. Whittington, badge number 1205, this was not a consensual stop, and there was not a reasonable suspicion that I committed a crime whatsoever. This is an essential element required for an officer to initiate a traffic stop. You can see that in Jones versus State, 727 South SC 2D 456, and that is the Georgia Supreme Court back in 2012. So the statements that I made during the stop were non-testimonial.
when made in the course of a police interrogation under circumstances.
Okay, so this guy's making an idiot argument. Well, first he made two separate idiot arguments. One I forgot to mention earlier, and one he's making now. The first one is that, or I think he might be making the second one, one I'm thinking about upcoming. But the primary one is he's saying like the cop can't testify to the interaction in traffic. It's the dumbest thing I ever heard. Seriously, it's so stupid. Two, he's going to say that the officer's testimony can't be admissible because he works for the police department, which is obviously has an agreement or is a creature of the city, which is prosecuting him. It's the dumbest thing I've ever heard. But luckily the judge, all the reason why I like this is because the judge completely throws down his BS at the end of the day.
Circumstances objectively indicating that the primary purpose of the interrogation is to enable police assistance to meet an ongoing emergency. There was not an ongoing emergency going on whatsoever. So the officer, EJ, badge number 1205, he actually committed an illegal traffic stop because in the United States Supreme Court, it held that the patrolman may not stop motorists at random to inspect their driver's license or vehicle registration papers, absent some specific articulable suspicion of wrongdoing, which there was not. And you can see that in Delaware versus Prost, 440 U.S. 648, 99 SC 1391, 59 LE 2D 660, and 1979.
Hold on just one second.
Yes, sir.
Is Officer Witherington available today?
No,
Okay. All right.
Well, in terms of, and I
Okay, here it is. He's going to raise probably the dumbest argument I've heard yet from one of these right to travel SovCits.
sorry to interrupt you, Judge, but I think perhaps in terms of his testimony and getting to the fact of why his testimony would be void, and I'll get to that in a couple of minutes here, but high level, just to make the court aware, there is a contract between the City of Ball Ground and the Ball Ground Police Department. And because there is a relationship there, then I would be prejudiced if he were to testify against me today. So we can jump to line item 29 and self-authenticating evidence, the contract between City of Ball Ground and the Ball Ground Police Department.
28.
I'm sorry, excuse me, 28, yes, sir. My apologies. So the contract between City of Ball Ground and the Ball Ground Police Department has voided the testimony of Officer EJ, badge number 1205, because Hines versus State, 290 SC 2D 911, Georgia Supreme Court 1982, states such testimony would be void if a witness or an accomplice may have substantial reason to cooperate with the government that a defendant be permitted to search for an agreement between the government and the witness. United States versus Crumley, 565, F2D, 945, 949, Fifth Circuit, 1978. Whether or not such a deal exists is not crucial. United States versus Mayor. What counts is whether the witness may be shading his testimony in an effort to please the prosecution.
So the court case he's citing has to do with a witness who may have had who is greasing his testimony to make him look good to the state for a better a plea agreement. In other words, like a defendant's friend or defendant's accomplice is testifying against the defendant in hopes that he'll look better to the prosecution. And so that would be a prejudicial form of testimony to make. There's an argument that because or that there wasn't, in fact, an agreement between the prosecution and the defendant that it may taint his testimony in favor of the state against the defendant. That's fine, but that's separate. Number one, that's separate from an officer and the defendant. The officer isn't making an agreement with the state to a lesser charge. He's a police officer. He might be prejudicial. He might lie. That's fine. That's a thing that can happen. But the second thing is, even if we were to say that there is an influence with the officer, he's still permitted to testify. This idiot is trying to argue that the officer cannot testify at all, like whatsoever, due to his relationship with the township or the municipality. It's so stupid.
A desire to cooperate may be formed beneath the conscience level, in a manner not apparent even to the witness, but such a subtle desire to assist the state nevertheless may cloud his perception and makes his testimony void. So basically what we have is a UTC which is not allowed to be used as evidence, but it is allowed to summon me to the court today. So the only type of evidence that we would have is the testimony of the officer, which would be void based upon the contract that Ball Ground has with Ball Ground Police Department.
All right. I have a couple of questions for you.
Yes, sir.
On page 3, you argue that the
UTC, Uniform Traffic Citation.
Uniform Traffic Citation is void because it doesn't state the essential elements of the crime.
Yes, sir.
What essential element are you alleging it doesn't state?
Well, today I'm just challenging the jurisdiction of the court. I'm not actually getting into the alleged charge that's being taken against me. So, that would be, I would assume that would be for a later date if this moves past my motion to strike here. But at this time, I'm not arguing the essential elements. I'm basically stating that they're non-existent, number one. Number two, even prior to that I'm in the wrong venue and this court doesn't have jurisdiction because the proper elements haven't been met to even bring me to this court today.
Right, but that's what I'm asking. Which element are you alleging hasn't been met? Because, that goes to the substance of your motion. Well,
that's a portion of the motion. Basically, what I'm saying is, if you look at the citation, I believe it's, what is it?
What am I doing?
OCGA 40, it's OCGA 40-2-8 B2A. And it states, it shall be a misdemeanor to operate any vehicle required to be registered in the state of Georgia without a valid numbered license plate properly validated, unless such operation is in other words permitted under this chapter. And it goes on to, various things that it could potentially be either exempted, not required, or again, in this particular case, elements have not been met.
Yeah, the judge is like, well, where have the elements not been met? Because the judge has probably seen these citations happen all over the place and all day, every day. So he knows that the citation likely, he already knows that the citation will, assuming all the proper information is filled, it's going to be presumed to have the essential elements available. And what was I going to say? And then the burden shifts to the defendant to say, where does it not satisfy the elements? And why is my game?
So the UTC does not state all of the elements that's required for this statute to be applicable to me. And I'm not going into
which one are you arguing?
Well, I'm not arguing. What I'm saying is the UTC, it only says operating vehicle without a valid tag or detail. So you guys tell me the elements that you're bringing me to your court to answer for, and I'll tell you why they're not applicable to me. So, but this UTC is the charging instrument, so I can't answer outside of the charging instrument.
All right. Well, the citation appears to indicate the offense that you're charged with, an operating vehicle without a valid tag, and it cites the Code Section 40-2-8, subparagraph 2A. Is there a particular element you're saying has not been met, or are you just? What
I'm saying is, pursuant to the law, a UTC, a Uniform Traffic Citation, is supposed to list the essential elements of that particular statute. Mm-hmm. This UTC does not do that. It is a very general, here's the statute, you're in violation of it. There is no way for me to defend myself based off of this charging instrument. And obviously, as this court knows, if you don't have a valid charging instrument, then I shouldn't be in here answering to something that is made up. So that's my challenge.
Okay. All right. The other, I guess the other factual question I have is that on page 4, no service has been commenced on William, Brandon, Spencer. The citation has a place for a signature.
Well, this is I believe this is a motion to dismiss. So he is arguing. He's supposed to be arguing.
And it's written on there, refused to sign. Are you denying that you received a copy of your citation?
No, sir.
When it was issued?
No, sir, I'm not denying that.
Okay. All right. Well, that's all the questions I have. If the state would like to respond.
So I guess just, first of all, I don't know if I overlooked the reasonable articulable suspicion aspect of the motion, but when you brought that up, we're not ready to proceed on that today.
Right, I was going to say, to the extent that everything after paragraph 23, or I guess part 4, paragraph 23 appears to be, even though it's not labeled as such, in the nature of a motion to suppress.
Yes.
He has orally said that that he has alleged all of those things not as a motion to suppress, but simply as an argument that Officer Witherington is not allowed to be or is not permitted to be a witness against him. I think we can argue that part of it, but not the merits of essentially what I think otherwise would be a motion to suppress.
So, from what I heard and what I understand, basically we're looking at, does this court have jurisdiction to hear the traffic offense Mr. Spencer's been charged with? I think the answer to that is unequivocally yes. CGA 40-13-21 vests municipal courts located within the state of Georgia the authority and the jurisdiction to hear traffic offenses of a misdemeanor nature. Mr. Spencer is charged with driving with an expired tag.
All right, so if you guys can't hear it, I know I try my best to run the audio through a filter to up the volume. But if you guys can't hear that, the prosecutor's saying that he was cited for and stopped for having expired tags.
It's a misdemeanor traffic offense, so certainly that is within the purview of what was contemplated by 40-13-21. The second issue that I've heard Mr. Spencer raise is a due process issue. Basically, the charging document, the citation, the accusation, however we want to phrase it, does not lay out all the elements of the crime, so he doesn't know what he's been charged with. I think there's a lot of case law that would indicate otherwise. The UTC that Your Honor has in front of you not only lays out what he's been charged with, the code section under which he's been charged with, but there are notes indicating specific elements of the crime that we would have to prove if the case went to trial. So Mr. Spencer is put on notice of what he's been charged with. There's the law is clear that you got to have a valid tag on your vehicle in the state of Georgia. They're operating a motor vehicle on the roadways of the state. That tag has to be renewed annually, and in the notes on the ticket, Officer Witherington actually laid out that this driver had not had a valid tag for in excess of 12 months. I think 13 months was specifically noted there. So all that to say, I think certainly this meets the baseline due process requirements of a uniform traffic citation.
Your Honor, if I may respond to that.
Absolutely.
So first and foremost, I guess this is the initial appearance as it relates to the uniform rules of the court, municipal court rule 20.1, whereas we're supposed to be, my understanding is per the rule 20.1c, we're supposed to be here to understand if you guys have probable cause or not. And as I've mentioned via United States Supreme Court cases and via Georgia, it was a Georgia Uniform Municipal Court Rule 20.1. I'm sorry, E, not C, E. And it says, in the case of a warrantless arrest, make a fair and reliable determination of the probable cause for the arrest unless a warrant has been issued before the first appearance. So no warrant has been issued, and I'm contesting that you do not have probable cause, as I've mentioned, via United States Supreme Court cases and Georgia appellate court cases. You do not have a valid charging instrument. If we're suggesting that the UTC is your charging instrument that is somehow obtained jurisdiction over me, then again, by law, you have to meet the essential elements by law, and you have not met those elements. So, for prosecution to say that you have checked the boxes to all the due process and this court's able to move forward is not accurate per the law.
He brought up some new arguments. Did you have any?
Again, as to probable cause or reasonable or typical suspicion, we would need, I think, court would need to hear some evidence on that. But just again, as a baseline, does the uniform traffic citation meet due process? It lays out the essential elements of the crime. It provides notes, and I think it certainly passed muster if we're making a due process argument on what's on the face of that citation.
Okay.
Well, and again, Your Honor, not to keep going back and forth, but again, today's appearance is to determine what probable cause is. If you need a testimony in order to determine that, then now we're outside of what the law actually says. Number one. Again, number two, I continue to say that if we're an actual indictment pursuant to the Georgia Constitution, and I can reference that again, requires the essential elements to be included on a charging instrument. This charging instrument does not have those included. Therefore, no probable cause has been established here. And if we're suggesting that we need testimony in order to establish probable cause, then I'm telling you that that is outside of what the law says. And I believe I've shown that here today.
Okay. Do you guys have any further?
Nothing further.
Nothing further, sir.
All right. The short answer is that I'm going to deny your motion. The longer answer is I'm going to explain to you why.
Sure.
So if you didn't hear, the judge denied, and he's going to explain why, which I think is pretty awesome.
First of all, as to the Uniform Municipal Court rule that you cited, 20.1E, the initial appearance hearing, that applies to a first appearance hearing pursuant to an arrest.
Okay.
And you weren't arrested, you were released on a citation.
But the citation said that I must appear. I'm sorry to interrupt.
I was going to say,
I just want to make sure.
Argument is over.
Sure. I just want to make sure you saw it said must appear on the citation.
Correct. And I'm going to do my ruling.
Sure.
I would appreciate it if you don't interrupt.
I apologize.
If you do keep interrupting, we'll figure out how to make sure that this
I understand.
goes on more smoothly. So the thing is, the Uniform Municipal Court Rule 21.1 just isn't applicable to what we're doing in court today. Number two, to address your issues regarding due process under the Georgia Constitution, the thing is the Georgia Constitution does authorize the establishment of courts at the state level, at the county level, and at the municipal level. And this court was established pursuant to those statutory rules which were enacted to allow for the establishment of municipal courts. The municipal court of Willingboro was properly established, and it is operating lawfully as a court of record that does, in fact, protect your due process rights, which is evidenced by the fact that we're here arguing your motion as opposed to making rulings without the opportunity for you to be present or for you to offer argument. On page 2 of your document, you've said that the municipal court of Willingboro is improper being court of record. The case you've cited is the Cass County case of Emerson, which is a Georgia Supreme Court case that actually the language you cited basically proves that we are a court of record. It holds that the court of record, or a court is a court of record if the court has the power to find an imprisonment, which we do. If the court exercises its functions independently of the person of a magistrate, which we do. The court proceeds according to the course of the common law, which we do in conjunction with statutory law, which is based on common law.
Which a very important point right there by the judge. These courts operate in accordance with the rules of the common law, as well as the statutes of the state of Georgia, along with which they themselves are originate from the common law. Which guru is this guy emulating? They both, this guy and the Texas guy, are from the same Telegram group. And they're both out of Alfonso Fagiolo's camp.
The court has a seal, which we do. The acts of the judicial proceedings are enrolled in parchment for a perpetual memorial and testimony, which is a legal term of art that has modernized into electronic recording devices and means of electronic storage based on computers and things of that nature. But the point is that all of that has been held to substantially comply with the idea of an enrollment in parchment for perpetual memorial and testimony. The conduct of the things that happen when you're in session. Rolls are also called the record of the court, which we have, and are such high and supereminent authority that their truth is not to be called in question. The records of the court are self-authenticated pursuant to Georgia law and are presumed to be truthful in terms of evidentiary value. So we are a court of record, even according to the case that you cited. Because we are a court of record, we are allowed to, that is part of the fact that your due process rights are being upheld. The lack of subject matter jurisdiction, when you argued that the essential elements aren't met by the citation, but when inquired upon, weren't able to state with any specificity what essential element has been left out of the document, and the case law regarding sufficiency of charging. Well, first of all, the motion that you filed is a motion to dismiss. The arguments you are making regarding the sufficiency of the UTC should more appropriately have been alleged as a demurrer.
So at first he's saying that he shouldn't have even done this as a motion to dismiss, but as a demur, which I don't, last I recall, isn't a thing in New Jersey. So demurs are more, I've heard of demurs being used in other states, but not really on.
But given given the circumstances that we're under, I'm going to treat it that way. In making my ruling, I treated it that way. But the elements for a charging document to be upheld, it has to, in a fundamental sense, to satisfy due process, place a person who is charged with a crime on notice of what they are charged with, and the Uniform Traffic Citation lists both the name of the offense, which is operating a vehicle without a tag, and the citation 40-2-8, paragraph 2, subpart A. It is also required to put you on notice of when the violation occurred, which it does, where the violation occurred, which it does. And so without you being able to specify any particular essential element that wasn't met, I find that all the essential elements of the offense are met by the Uniform Traffic Citation, and that Georgia law specifically allows under a violation of this nature for the state to proceed on a Uniform Traffic Citation in lieu of a formal accusation or indictment. As to lack of personal jurisdiction, the allegation that you weren't properly served, you acknowledged on the record that even though you refused to sign the citation, you did receive a copy of it. Personal service is...
Oh, yeah, he tried to argue that he didn't have personal jurisdiction or personal service, but he admitted that he received a citation from the cop. Congratulations, that's personal service. Yeah.
Always a valid means of service in the state of Georgia, and it did put you on notice of when you must appear before the court, and in fact, you're here today, so I don't see any violations of your due process rights based on personal service or notification to be in court. And then to the extent that paragraph 4, parts 23 through 28 allege factual circumstances, I don't think I can. The way that it's drafted, it is in the nature of a motion to suppress, which I don't think I can hear today without the officer being present. But to the point that you have orally indicated, the purpose of that was the fact that the officer can't be a competent witness against you because he works for the City of Ball Ground, and because the City of Ball Ground is also the authorizing municipality that the court's jurisdiction arises from. The cases that you've cited have to do with the state not notifying a defendant that they have made an agreement with the witness that could give them a motivation or could affect their motivation or credibility towards the finder of fact. Now, that being said, it's public knowledge that the police jurisdiction, that Officer Witherington works for the Ball Ground Police Department, and that we are appearing in Ball Ground Superior Court. So everyone is on notice of that. And even in cases where the witness is potentially, their testimony is potentially motivated or could be shaded by the fact that they have a vested interest in the outcome of the proceedings, there's nothing wrong. There's nothing that makes that witness incompetent to testify.
Exactly. Exactly. This is basic. Even if we were to say that the cop has some sort of vested interest in the outcome of the case, that in and of itself is not sufficient for him to testify. That goes to his credibility, and that credibility is determined by the trier of fact, aka the judge or jury. They'll determine whether or not that vested interest is sufficiently taints the testimony to render the officer's statements as not credible. But he's still allowed to testify.
As long as the nature of the prejudice is made aware.
Oh, and also the prejudice is, not outweighed by the probative conduct. And I would say the officer, being the guy who gave him the citation, his testimony is relevant enough to overrule the potential vested interest that he may have.
The finder of fact is made aware of that. So,
yeah.
In the cases that you cited, the factual situation was that a state's witness was a co-defendant to another individual, and that they basically made a deal with the state in exchange for leniency in exchange for the testimony. And the cases that you cite essentially indicate that the defendant that they're testifying against has a right to know that. Whereas instead of a co-defendant or a witness that the state can make a deal with, in your case that is before the court right now, is a witness that you can certainly argue has a motivation or a vested interest in the outcome of the case, and that motivation should be taken into consideration for purposes of the credibility of their testimony. It's just not factually.
Oh my God. Oh my God. Thank you, RA, for the $100, $99.99 super chat. What you drinking, Artie? Are there sea shanties in their future? No, there are not. But holy hell, thank you for waking me up, apparently. Wow.
The state making a deal with a witness and then not telling anybody about it. So that in that sense, in a situation a person's due process rights would be violated because they were not made aware of the bias of the witness. But here, you can always argue that a police officer is a biased witness.
Thank you, Eggs Ball and Gary, for the 14 and 27 months.
I'll deny the motion. If you want to have the portion of the motion heard as a substantive motion to suppress, we could schedule that at a future date to make sure that we have a witness here. As to the issue raised about new trials and appeals and things of that nature, if you disagree with the ruling that I have made today, you are absolutely within your rights to file an appeal. You can't file a motion for new trial yet because your case hasn't been decided on the merits. This is just a pretrial motion regarding some jurisdictional issues.
Oh my God, Jassa, thank you so much for your 6 months on YouTube and 19 months on Twitch. Jassa's been giving me his Twitch Prime for over a year, so thank you very much, Jassa. I appreciate it.
So you can appeal that. If, in fact, you are ultimately adjudicated guilty by the court, then you can file a motion for a new trial with this court. And then based on that, if we're granted a new trial, then you get a new trial. If we denied your motion for a new trial, then you can appeal. So there's nothing that your appellate rights, as far as a new trial, are not right yet. But as far as just appellate rights in general, you have all of those are available to you within the time constraints that the law allows.
Thank you. And sorry to interrupt you. May I say something?
Yes.
So just for the record, I'd like to raise exception to the judicial error of this ruling and go ahead and preserve that for a appeal. And also, if you wouldn't mind, I'd like to ask the court, how am I supposed to file motions into the case when I've been denied the option of filing motions into the case? I have self-authenticating information that
self-authenticating information
supports that.
From this point forward, any motions that you want to file, all you got to do is bring them up to the front desk at City Hall during normal business hours.
Okay.
And they will accept filing from you. They will notate the time and date, and they will place that motion that you filed in your court file for purposes of the record.
Okay.
And if the motion that we're arguing about today, if there's not a copy of it in the court's file,
you can keep that.
I was going to say I'll have it placed in the court's
Thank you.
today.
Well, and Your Honor, again, not to be, just want to make sure that all my rights are maintained. How is service going to commence on me as I'm filing motion into the case? This would be one of many motions that I want to file.
Let me ask you this: are you, from your legal standpoint in Georgia, you are welcome to represent yourself?
I understand. That's what I'm doing here today.
Have you been to law school? Or you
No, sir. I'm pro se. Yes,
okay.
sir.
All right. So you are allowed to represent yourself. The fact that you're representing yourself doesn't excuse you from any of the procedural rules that go along with filing motions. When you file a motion, it is required under Georgia law that a certificate of service
Yes, sir.
Be attached and that the opposing party be served with anything that you file with the court.
Well,
If the court has you're also required to keep your current mailing address on file with the city so that any future court notices or any motions that the state may file can be served upon you.
Yes, sir. Yeah.
So as long as we have your correct address.
I've done this.
Right.
And I'm saying
your correct address, you'll get all future court notices at that address, and you'll get any future. If the state files any motions, you will be served at that address as well.
Okay. And again, I mean, I've done this. I attempted to file into the case. We could have.
Right. And what I'm saying is, I'm not sure what happened before today.
Well, just again, just to make sure all my rights are maintained and the record is clear about this, that is a variable of due process, that I'm allowed to file motions into the case before even a pre-hearing, which it's undeniable that that was violated, A. B, as it relates to, and again, I keep harping on this essential elements of the UTC and apologize for going back there. I know you've already made your ruling, and I respect that, sir. But my point is, as an example...
I know you've already made your ruling, and I respect that, but I'm going to relitigate it regardless.
You know, if I were to do harm to somebody, go and hurt somebody, you can't just say, hey, Mr. Spencer, you hurt somebody. You'd have to say, Mr. Spencer, you took a baseball bat and hit somebody in the leg with it. Those are essential elements. This UTC does not, you know, again, you've made your ruling, sir, and I've
made the ruling, and number two, during the hearing, I asked you for specificity.
But that's not my responsibility, sir. It's prosecuting.
It's your motion to dismiss, so it's your responsibility.
But it's the court's responsibility to show how you've obtained jurisdiction.
No, idiot. The judge has already basically asserted that the UTC has all the elements in there. The onus is on you to show that there's a defect in the UTC.
Over me, sir. Yes, sir.
All right, so here to the...
But as the judge just mentioned there, we've already gone through this, and again, he's, as I said, he's trying to relitigate his argument.
And to address your issue of not being allowed to file the motion.
Yes, sir.
Today, let's assume that was a violation.
Would you like my self-authenticating email that I received from your office? Because I have that right here that shows I was denied.
Self-authenticating email from him to the office.
No. Like I said, I'm going to assume that they didn't allow you to file something in the case. We did allow you to file it today, and I gave you an opportunity. I gave both parties an opportunity to move the court date to some point in the future before we argued this, if either one of you needed any more time to do anything. So, in that sense, to the extent that there was a violation of your due process, it was corrected by giving you the opportunity to have more time to make your argument. And we got the assurance that in the future this won't be an ongoing issue. Anything you want to file, bring it up here during ongoing
Sure.
hours.
Well, and with respect to that, sir, you know, other than today, I have not heard what.
That's what I thought. That's what I thought. That there are certain records that are in fact self-authenticating. His email to the court is not one of those. And that's what I was trying to remember, because I was trying to remember that usually, like, government documents, like a certified copy of a birth certificate, for example, is a self-authenticating document. But also things, so, and also in this example in the rules of evidence, official publications, newspapers, and certified domestic and foreign records of a regularly conducted activity, most commonly referred to as business records. So, so there is such a thing as self-authenticating documents, but they're not documents that he made himself. For example, his freaking email to the judge. No.
The defense would be in reference to my allegations on this court. And therefore, you know, I don't recall getting an option to reschedule this hearing to be heard at a later date. Number one, because I have not even heard, other than today, what the defense would be. I have no idea how to defend myself. I submitted a motion, and it was heard, you know, and prosecution made their rebuttals to it, which is the right thing to do. But I have no chance to study or figure. I'm pro se, so you know you have to liberally construe the rules.
No. Liberally construing your filings is what the court can do, but you're still subject to the rules of procedure themselves. In other words, the deadlines, the applications, the write-ups, the briefs, etc. You still got to do that, buddy. That's not what liberally construing pleadings affords you.
So even if you were an attorney, nothing would, other than
understand.
Continuing.
Yes, sir.
Offer both of you. There is no other remedy. And number two, like I said before, you're welcome to represent yourself, but the rules don't change just because you're not an attorney and may not be familiar with it. That's one of the downsides of representing.
Sure, understood.
And there aren't any rules that have been violated or that have There aren't any rules regarding what we've done today that would have been any different had you had a lawyer here and they would have followed it on your behalf.
Okay.
That sort of thing. So, at this point, what we're at is I've denied your motion.
Yes, sir.
You are welcome, and we're going to reset your case for, what's the February date? February 17th. If you want to file any more motions, you can file anything you want. If they are substantive motions that require witnesses to be present, if they're witnesses that you want to have here, then you've got to follow all
Yes,
the
sir.
rules on subpoena.
Yes, sir. I'm familiar.
Based on anything that you file, the state will get with their own witnesses here. And what I anticipate is that on the February court date, if there are substantive motions that we need to hear, we'll hear those that day.
Okay.
If there are not substantive motions filed between now and then, then we'll go forward. If you want a trial, we'll go forward with the trial of the case.
Oh crap.
And that, forgive me, so the February 17th, is that the trial date? So,
Hey, thank you very much to Condros for the 5 gifted memberships.
because I need to,
Unless we have motions. And now, maybe that we could do the motions and proceed.
well, I'll have some depositive motions that I'll be submitting for sure. However, we need to discuss the discovery process of this matter. So how am I going to, do I get the prosecution's contact information so I can conduct my discovery?
The discovery is all governed by Georgia, by statutes.
I understand. I'm just saying I don't have a case number and a party
as long as you
to.
file the right motions,
Uh-huh.
they are required to give you discovery, and
Okay.
you're entitled to it 10 days prior to trial. So as long as you file the correct motions more than 10 days prior to trial, then they'll serve discovery with you at least 10 days prior to trial.
Okay.
If we show back up in February and you have filed all the correct motions, but they haven't given you discovery, if they haven't complied,
Right.
then we'll have an inquiry into why they haven't complied, and we'll, if they haven't, we'll grant you a remedy based on what the
Yes, sir.
explanations are.
Well, thank you very much. I appreciate that.
Okay. All right, very good. Well, then, that'll conclude this matter for today,
Okay.
and we will reconvene on February 17th. February 17th.
Thank you for hearing my motion.
Very good. You're welcome.
Do you guys print anything out for me? Thank you so much.
And there we have it. I mean, getting a motion for a new trial on a traffic ticket isn't unheard of, and it's not unknown. That's fine. I don't. That's not the issue here. But his issue is one. I think he tried to shoe in a motion for a new trial on an. I don't know why he tried to shoehorn in a motion for a new trial when the trial hasn't even occurred yet. Number one. Number two. He tried to file a motion to dismiss when, according to the judge, he should have filed a motion for demurrer. And filing a motion to dismiss before the trial is also, that's fine. That's not unheard of. It's just his arguments within his motion were completely ridiculous. And also, Gary, I saw your comment there. I mean, it traffic tickets, depending on what they are, depending on the seriousness of them, discovery is a normal thing. Discovery can include, getting the calibration report on the radar, the calibration report on the breathalyzer, for example. So discovery in a traffic case is fairly common. That's not an issue either. It's just that his arguments in this motion to dismiss is your typical SovCit BS, or, I mean, sometimes not even SovCit, just a complete failure in understanding the law and the rules of procedure, and basically cherry picking the law to suit his needs. So I was gonna just keep on opening up some games that I haven't played in a while, but I've touched Red Dead Redemption in like ages. All right, we can. It's real quick, but we could take a look at the original audio, the original video from Van Balling posted today. I have all 3 of them. They're like a conjunction of 3 short videos that this guy posted that serves as Van's latest one. So shout out to you, Van. Oh wait, I can't access it right now. That's okay. YouTube. There we go. Pop out. There you
No, I pulled you over today. You have an invalid inspection. Do you have license, registration, proof of insurance? Do you have those things? Because if not, we're going to tow your car.
I'm not doing commerce right now.
What was that?
I'm not doing commerce right now.
Okay, well, you have two options. You can either provide me that documentation, or you can be towed.
I'm sorry?
You can either provide me your license, registration, proof of insurance, or we'll tow the vehicle.
Why do I need insurance for or proof of?
So if you're going to hand me that documentation, you can do that, or we can move on from there.
This is out of Pennsylvania.
I don't need that if I'm traveling.
I can't hear you. Can you speak up, please?
I do not need insurance if I'm traveling. I'm not doing.
You do?
No.
So you're telling me you don't have insurance on this vehicle?
I did not say that.
Okay, do you have your insurance?
I don't answer no questions.
Okay.
Am I being detained?
What was that?
Yes.
Am I being detained?
Yes, you
You're
are.
on a traffic stop. You're being detained.
For what?
Huh?
It's at max volume, Nada.
What is the crime?
What was that?
What is the crime? What is the emergency?
You don't have a valid inspection.
But all crimes are commercial. Where's the victim?
Hey, I copy. What was that, sir? Alright, go ahead and step out of the vehicle.
Am I being detained or I'm free to go?
You are. Step out of the vehicle.
Am I free to go?
Sir, I'm not going to ask you again. It is within my right to ask you to step out of the vehicle.
And
step
it's
out of the
within my
vehicle.
right to stay in the car if I'm not
gonna
being
tell you again.
detained.
Step out of the vehicle.
Am I being detained?
They already answered you.
Johnny, can you have 702 meet me in front of the courthouse?
Meet him in front of the court. Oh, that's right. Van mentioned that he just got out of jail. Like he just got out of jail or out of jail just now. All crimes are commercial, of course. Yeah. Oh, that's right. That's another meme that I've heard. Danny pointed this out. The meme that all crimes are commercial, and Juan Galt probably knows this too, comes from like a lot of them. Whenever I ask them about that, they cite to an ATF regulation that defines. In the regulation, it defines, okay, the following crimes, for the purposes of this chapter or purposes of this title, whatever, the following crimes are considered to be commercial crimes, and it lists a whole bunch of crimes, a lot of them. Don't get me wrong, there's a lot there, like wire fraud, prostitution, trafficking, a whole host of things. So they say, oh, look. So a lot of these SovCits are like, oh, look at this massive list of crimes that are decidedly commercial. Therefore, all crimes are commercial. Well, guess what's not listed on there? Murder, rape, assault, a lot, traffic violations. A lot of these crimes are not listed on there, but because they think that it lists everything, they just assume that all crimes are therefore commercial. It's so stupid.
702, could you meet 708 in front of the courthouse? He's on a traffic stop. Copy that. 705, 1 County 5.
That's part one. There's 3 parts total. They're all they're all about 2 minutes a pop.
705. We'll be out of the jail with that new female on acknowledge 40989
Sir, I'm going to ask you again to step out of the vehicle. Are you going to comply?
Am
or
I
not?
being detained, sir?
You are being detained.
For what crime? Can
Your
you cite the
vehicle's not
penal
inspecting,
code?
so
What
you
is the
step out
penal
of the vehicle.
code? But I don't need a registration because I'm not driving right now. I'm
I can't hear
traveling.
you. You're going to have to speak up.
I said I'm traveling.
No, you are driving. You are behind.
No,
the
I'm
wheel
not
of
in
the automobile
commercial.
on the
No, I'm
road
not.
of the
I'm not.
Commonwealth.
I'm not in
You are
commerce right
driving.
now. You are in commerce, sir. You need a driver license and you need a registration. I don't. I'm not doing commerce right now.
Okay.
Am I free to go?
No, you're going to step out of the vehicle. You are
Am I being
detained.
detained for what? What's the penal code? What's the penal code?
4703 of the
What is
Pennsylvania
that?
Vehicle code.
What is that?
What?
What is that?
You were being pulled over because your vehicle is not inspected, and that is an infraction of Title 75 of the Pennsylvania Vehicle Code. Eight, I copy. He's refusing documentation. He's refusing to step out of the vehicle.
That's right. I forgot. Part 2. This is his title. Part 2. Police of Warren County, Pennsylvania, stalking me out of jail.
Oh, he says he's traveling.
Warren County 708. Would you like a city police officer to your location? Warren County, I'll be on my duty.
708 County. That's negative at this time.
Copy 708.
All right. We're on the last one. Part 3. I don't know what he was in jail for. No, what he was originally in jail for.
All right, so here's the deal. You can't move this vehicle from the spot that it's at. If you
Sir.
move this vehicle from the spot that it's at, you'll be pulled over again. You're going to be...
Oh, they're letting.
Sir, what a charge is?
What?
What a charge is?
Don't let him go.
A charge is a bill. You are forcing me to receive a bill. You're
I'm not gonna
forcing me
argue with you.
into
Your out of
commerce.
inspection and your registration's expired.
I didn't put that in there. It was already there when you got the car.
Correct.
So
but
that's
that
illegal?
has to be maintained to drive on a Pennsylvania road.
No, if you're driving, I'm not doing commerce. I'm traveling. I already said 100 times I'm not doing commerce. You are doing commerce right now. You're forcing me to contract. That's coercion.
Officer to respond.
I can only assume that he probably had a more pressing incident that called in.
County, that's negative. Okay, you can't move this vehicle. That's the bottom line. You can walk home and you can park it here, but you can't move this vehicle.
Where's the
On a roadway of the
citation?
Commonwealth. You can't.
What is the citation?
No, you can't. And I'm not going to argue with you.
No, the
If you do it
citation.
again, you'll be pulled over and you'll be cited again.
I said a citation. Where's the citation?
Huh?
Where's the citation?
You'll get it in the mail because you refuse to provide me your documentation.
Oh, thank God. They did get it. All right, they did cite him.
Give it to you right now.
Okay, I will receive it.
They probably cite the car. Oh, Akira says. I guess I missed that part. Akira 808 State says the printer in the police car wasn't working. Well, that sucks.
Okay. So whatever you do, but you can't drive. You can't.
I'm not driving. I'm traveling home. I'm not driving.
And he's just probably gonna wait for the car to go.
Have a gun? He's telling me that I cannot leave this spot. I already told him that I'm not driving, that I'm traveling.
Okay.
He's forcing me to engage in a contract right now. Forcing me. I'm coerced.
Shut up. That's disappointing. But well, it looks like he just started his YouTube channel 3 months ago. Hopefully he'll get caught up again and gets arrested again.
For that, that's not something.
Okay, so I'm gonna call it here. Nat invited me to her live stream that's still ongoing right now, talking about the Murdoch case. But I'm talking for a lot. I'm kind of tired. kind of want to play some video games. But I will at least stop by and say hi to Nat. No Kitty, they're not here. I fed them decently ahead of time, so but I'll talk to you guys later. Go check out Nat's channel. Tomorrow I'm going to be going back to Dead Space. I promise. I know I missed out yesterday. I know I should. Yeah, I should. All right. I'll jump in on Nat's live stream and drop in. But guys, check me out over there. I'll stop by for a little bit. And but tomorrow I'm going to be streaming Dead Space. I promise. Friday we're going to be will be our usual Friday open bar. I'm going to see what I can have in store for that, but that's going to be TBD. So thanks guys. Check out Nest channel. See ya.